all of you to this very important session on this beautiful Saturday morning. In spite of last date for filing returns, transfer pricing returns, we have a good number of people online, and we are sorry for this little delay. Friends, we have amidst us today Mr. Rajat Bansal, a good friend of IFA, a good friend of anybody who wants to learn something and is ever ready to share his knowledge on the subject and his vast experience on in the field of international taxation, and very humble, uh, very pleasing personality, and it is always a treat to listen to him. So welcome, sir, and thank you very much for accepting our invitation. And may I now request Prerna to introduce our speaker. Today we are going to learn a very important subject on dispute resolution, and that is something which is very important in the days when your litigation is on the rise, and how can we prevent rather than cure. So over to you, Prerna.
Sure. So Rajat Bansal sir is a retired IRS officer who has last served as Principal Chief Commissioner International Tax, heading all the India operations for TP audits, APAs, audits of MNE's dispute resolution panel. He was also a member of first GAR panel in India. He has in fact steered insertion of Article 12B in the UN Model Tax Convention, which is popularly known as Bansal Proposal. He was India's first transfer pricing officer, and he has also won the award for highest resolution of transfer pricing cases, OECD award, in 2019. He was a single point of contact for India for BEPS MLI matters, the Global Forum for Exchange of Information and Transparency, Forum for Harmful Tax Practices. So welcome you, sir, and we look forward to your session.
Good morning to everyone. As Mayurji said, it's a beautiful Saturday morning, and we are now having a very interesting and rather complex subject, which is MLI. And MLI, I would rate as one of the most complex international document or agreement, as one may call it. And you have had this workshop for, I think, now quite a few sessions, and I believe that you would have already seen what kind of a document MLI is. And at the outset, I will say that it's very different from any other document that was there before it came into being. And I mean, when one talks of multilateral instruments, then there was no multilateral instrument of this kind in tax before MLI was drafted and finalized. Incidentally, I was a part of the MLI ad hoc group which drafted this, and I participated in the ad hoc group meetings. Thereafter, I also participated in the the single contact person for India for finalizing the India position on MLI. So I finalized the India position. I had speed matching meetings with competent authorities or single contact persons of other countries to finalize it and give it at the provisional position in the beginning, and thereafter final position along with the ratification instrument when it was submitted later. So I have seen the MLI evolve and what happened at various stages. So with this, I will start with this presentation, for which I think we have 1 hour and around 15 minutes or 10 minutes now. And I'll just give you at the outset what kind of plan I have for this session. I will be initially touching upon the genesis of MLI, how it came into being. Thereafter, I will focus on the basic structure of MLI, just to recapitulate for you how MLI operates. And then we will go to Article 16 of MLI, which is about the dispute resolution, or rather the MAP article insertion in the bilateral tax treaties, which the MLI is intended to do. And then I will touch upon the Article 17, which is also placed in the dispute resolution part of the MLI MLI document. And then I will move on to certain other aspects of MLI, not MLI, but dispute resolution. I thought I'll take this opportunity to familiarize everyone with few other aspects, like what are the other minimum standards in the BEPS Action 14 plan relating to dispute resolution, and then what is the India position on various aspects of some of the important aspects of the dispute resolution action 14, such as the India map profile, or India map position, or the rules in domestic law relating to the map provisions in various treaties. So we'll start. Next slide, please. So this is just a picture to show to you the MLI signing on 7th June 2017 at Paris. You can see the finance minister and you can see the member CBDT at the back. And this is the room in OECD where this signing or the negotiation took place. Next slide, please. Just to give a bit of a background about BEPS project. So BEPS project originated due to the financial crisis during 2008 to 2012. And thereafter, G20 under Mexican presidency called for OECD to address BEPS, which is base erosion and profit shifting. And the BEPS project, I must compliment OECD for this, that when I mean, it's very difficult to conceive of everything what you will achieve at the end for anyone. But at this time in BEPS project, there are, if you look up, 13 action points, and each one has its task cut out in the beginning itself. And within the time frame which was laid down, the BEPS project completed all the projects, all the 13 of them, 15 key actions, all of them were completed. And there was a document detailed guidance or recommendations issued in respect of each of them. G20 endorsed the BEPS package in 2015 when it was finalized. Next slide, please. So basically, there are 15 action points, 15 being the multilateral instrument. Strictly speaking, it should not be included in the BEPS action plans or BEPS action reports. So other 14 BEPS action reports are always broadly categorized under three subheads. Firstly, coherence, second, substance, and third, transparency. Since focus today is on a different aspect, I'll not go into the detail, but these are the three basic categorization of the BEPS action points or action plans. That is always, since it was conceived and since it was delivered under these categories, it has been talked about. Digital economy was kept on a separate platform, and we'll not talk about it in this session. As we all know, that's still going on. Next one. Next slide, please. So MLI was basically an instrument, as you would have learned, to speedily include the provisions relating to the BEPS recommendations in the bilateral tax treaties. 3,000 treaties are always referred to as existing, and bilateral negotiations would have taken very long. So instead of bilateral negotiations, MLI was kind of a versatile attempt to do it at one go. And MLI did not choose to include all the action plans. It only included these 4 action plans for coverage. And all of them are basically having some kind of minimum standard under them. There are 5 minimum standards under the BEPS action plan, and MLI targets quite a few of them for facilitating implementation of the minimum standards by the jurisdictions. Next slide, please. Now, mechanics of MLI you would have learned. So, but just to recapitulate, specifying tax treaties cover tax agreements, then flexibility with respect to minimum standard provisions. We would see this today also, but there is a lot of flexibility even in respect of minimum standards, which all signatories to the inclusive framework later, with inclusive framework means the countries beyond OECD and G20 countries, which were the drafters of the BEPS action package, and later further were added exceeding 100. So all of them are supposed to implement the minimum standard, 5 of them laid down under BEPS project. Opting out of non-minimum standard provisions is very much possible. Opting out of provision for treaties that contain certain existing provisions with specific characteristics. So what it means is that there would be treaties which would already have certain provisions which the countries may not want to be superseded by MLI, and therefore opting out of them is possible. Choices to apply optional and alternative provisions, including Part 6 on arbitration. Next. Structure of substantive provisions. So this is very important, and I'm sure you would have understood this by now through this course. So how the MLI articles are structured, there would be a paragraph which would contain the substantive provision which is intended to be inserted into the treaty. Then compatibility clause, what does it mean? It means that the kind of provisions which are similar to what we are intending to introduce, so the interaction with them is necessary to be spelled out in the instrument, and compatibility clauses are often positioned just below the substantive provision, not often, always positioned below the substantive provision, and then it defines the relationship between the provisions of the convention and the cover tax agreements. Reservation clauses, because as we noted, countries have the choice to not include certain recommendations or certain provisions proposed to be inserted through MLI. They can reserve, and that's how a reservation clause is there in various substantive articles. Next, please. Notification, what is the purpose? To make because you see, MLI is an instrument which is different from an amending protocol. An amending protocol would substitute the existing treaty with new provisions, and then it will be a standalone document through which one can work. Whereas MLI is an instrument which sits along with the bilateral treaty. It does not amend the bilateral treaty, and it is to be read together with the bilateral treaty, and somebody else has to interpret and understand how it will operate. So to facilitate that, notifications are to be made by countries, which they did at the time of signing and at the time of submitting the instrument of ratification, through which one can now decipher how each clause will operate and how it will get implemented. I will explain. This will become very clear when we go to Article 16 operation. Next slide, please. Now, this is also very important. What is the mechanics of compatibility clauses? So the first is that in place of what kind of wordings you will find in various paragraphs of MLI, there would be in place of, then there would be applies to or modifies, in the absence of, in place of, or in the absence of. This also, I'm sure you would have understood by now, but it would be clear more from the discussion about Article 16 of MLI as we proceed. Next slide, please. So BEPS Action 14 is the one which is the topic of discussion today. As I said in the beginning itself, there was a objective laid down for all the actions of BEPS, and this is the one for Action 14. And finally, Action 14 also had 16 minimum standards and 11 best practices. Next slide, please. These are the elements of the minimum standard which are set out. Basically, three major objectives were there. First was that countries should ensure that treaty obligations related to the mutual agreement procedure are fully implemented in good faith and the MAP cases are resolved in a timely manner. Countries should ensure that administrative processes promote the prevention and timely resolution of treaty-related disputes. Countries should ensure that taxpayers that meet the requirement of paragraph 1 of Article 25 can access the mutual agreement procedure. Next slide, please. Now we would look at the elements of minimum standard under BEPS Section 14 which are implemented through MLI. So let me explain this. There are minimum standards which are not implemented through MLI, and those are, for example, there is a minimum standard that countries should publish their map profile, or there is a minimum standard that countries will subject themselves to a peer review done by FTA Map Forum, or several others of those kinds. So all those will be are not under MLI. MLI is basically to get the theoretical framework, or rather the substantive provisions relating to map under the treaty. So element 1.1 it is half of element 1.1 that we are looking at here. Rest is also taken up in this session later. Countries should include paragraphs 1 through 3 of Article 25 in their tax treaties as interpreted in the commentary, and subject to the variations in these paragraphs provided for under elements 3.1 and 3.3. What is element 3.1? So basically 3.1 is about the map request being allowed to be made to either competent authority. That means competent authority of either contracting state. As you would know, till now, or rather before the BEPS project, the provisions were to make the map request to the country of which the person is resident, and in case of a national relating to non-discrimination map matter, to the country of which he was a national. And then in the BEPS project, it was changed to allow this to competent authority of either country. The purpose was avoidly to allow map access to everyone and not allow a competent authority to reject or discard a map request without no other competent authority coming to know about it. So till that, it was still something, because India has a reservation on this, that's why I'm telling you. Then other part became that the country to which it is presented map request is expected to resolve it on its own first, and then only approach the competent authority of the other country. So here you can understand that suppose the adjustment is made in country A and the map request is made in country A, so it's kind of an appellate function being asked to be discharged by that competent authority to which we were not in agreement, and therefore India has a reservation on this. And the minimum standard provides for an alternative to implement a bilateral notification process through which the other competent authority can come to know about a map case being not accepted by the first competent authority to which it is presented. Element 3.3 is about basically implementation of map requests without any time limitations under the domestic law. So as you would know, map article after 2017 OECD model update makes it implementation of map resolutions without any restriction of the time limitations under the domestic law. And this is the element which refers to this, but it also carves out an exception that if a country decides that it would not allow a adjustment relating to attribution of profits to a permanent establishment, or a transfer pricing adjustment beyond a fixed period. I mean, it cannot be indefinite period to which this adjustment can be made, and it is limited by that country, then it is within its rights to reserve against this kind of insertion in its tax treaty. Next slide, please. So here I am just showing you basically MLI is intending to, as you saw in element 1.1 of the minimum standard, the idea is to insert Article 25 first three paragraphs into the bilateral tax treaties. So first paragraph of MLI is Article 16 is listed on the right side, and Article 25 of OECD Model Tax Convention first paragraph is on the left side. And as you can see, it is exactly the same except some adaptation changes One is, of course, jurisdictions are talked of in MLI instead of states, so that's all right. But other than that, instead of some changes you can see, I'll not go into them. They're obvious that those changes are made just to make it a kind of application for everyone joining the MLI. Next slide, please. So this is the second paragraph, which deals with the resolution part, that if a competent authority is not able to arrive at a satisfactory solution, then it would approach the other competent authority, and any agreement reached, second sentence, any agreement reached shall be implemented, notwithstanding any time limits. So this is the same thing which is there on the right hand side in paragraph 2 of Article 16 of MLI. Next slide, please. Article 25.3, which we all know, is about endeavor by the competent authorities to resolve by mutual agreement difficulties or doubts arising as to the interpretation or application of the convention. This is an important part of the convention, and then they may also consult together for the elimination of double taxation in cases not provided for in the convention. So if you read the commentary, OECD commentary on Article 25, paragraph 3, this would become more clear. I'm sure you would have read it. So this is a very useful article, and it is a useful paragraph of Article 25.3, which serves many purposes, including the entering into of bilateral APAs by countries. Because as you would know, there is no other bridge or between the two countries in the tax treaty so far, and it is Article 25.3, which is always referred to as the bridge for mutual agreement procedure in respect of a bilateral advance pricing agreement. Next slide, please. So these were the three paragraphs which are intended to be inserted into bilateral tax treaties to fulfill the minimum standard 1.1, which we saw little back. And now MLI has housed all these three paragraphs of Article 25 in it, and first three paragraphs of Article 16, as I showed them to you, and as you can see, are the ones which are intended to be inserted. Now, in these three next slides, I have tried to demonstrate to you the mechanics which I showed to you earlier about compatibility, about reservation, about notification. So how would that operate through next paragraphs, which are, these three are the first three paragraphs of Article 16. Thereafter, there are paragraphs 4, paragraph 4 is the compatibility clause, paragraph 5 is the reservation clause, and paragraph 6 is the notification clause. So how would all those operate together? I have captured in this slide and next two slides, and this would make you understand very well how this article is going to work. And similar exercise you can do for all other substantive provisions. When I say substantive provisions of MLI, I mean articles 3 to 17 of the MLI. And there you can find similar provisions, varying to some extent, of course, depending on the content. And then you can see. And firstly, I would like to tell you that each paragraph 1, 2, and 3 is comprising two sentences each. And to recapitulate, I will quickly tell you what those sentences are so that you can make more sense out of this sheet. The first paragraph, first sentence is that where a taxpayer feels that the action by a contracting state is not in accordance with the convention, he can present his case to either competent authority. Sentence 2 of the first paragraph is that the request is to be made in a time which is at least 3 years. Second paragraph, first sentence is that if the competent authority is not able to resolve the matter on its own, then it will approach the competent authority of the other country. Second sentence of paragraph 2 is that the MAP resolution reached will be implemented notwithstanding any limitations of time. Then third paragraph, first sentence is that the competent authorities will consult each other if there is any difficulty or doubt in relation to the bilateral treaty. Then next is that, next I'm forgetting, but something similar to this is in the next one also. Can we see just the previous slide, Kush or Prerna? Just the previous slide, just previous. Yeah. So the second sentence is, they may also consult together for the elimination of double taxation in cases not provided for in the convention. So next slide, please. Now, this is, as I said, a summary of articles, MLI's paragraph 4, 5, and 6. So, first sentence of Article 16.1, how the MLI will act upon it. The parties have a flexibility to make reservation. So, if either party makes reservation under Article 16.5a, then if it is yes, then first sentence will not apply, and that will entail, as I was telling you, that the bilateral notification process will have to be done. If it does not make, if no party makes reservation, then do all parties notify same provision under Article 16.6a? If yes, that provision is replaced by first sentence. If no, first sentence of Article 16.1 applies and supersedes provision to the extent of incompatibility. So it means that if there is a one party feels that there is already a sentence of similar to the article first sentence of Article 25, paragraph 1, and it does not notify that under the paragraph Article 16.6, under Article 16.5a, then the supersession will be only to the extent of incompatibility and not in full. Coming to second sentence of Article 16.1, which is about the time limit of 3 years, does either party make reservation under Article 16.5b and notify that the CTA is within the reservation? So if yes, second part sentence will not apply, because why is this? I'll give you a little bit of background. If you see the explanatory notes to the MLI on this reservation, they would, there it is explained that sometimes in the domestic law of the country there may be already time limit more than 3 years allowed, and a country may want to preserve that time limit and may make a reservation. So with that view, that reservation is permitted. Now, if yes, second sentence of Article 16.1 does not apply. If no, then if both the parties make the same notification which about the agreements which are having a time period shorter than 3 years, some agreements are there of this kind, we will see later, then yes, that provision is replaced by second sentence of Article 16.1. If no, then does either party notify existing provision under 16.6b2 at least here? So you see here the designing of the provision is somewhat like this, that where there is a time limit allowed which is more than 3 years under the treaty itself, and a notification is made by a party in respect of that kind of provision, that is preserved. So then if either party notifies 16b2 16.6b2, then second sentence will not apply, and if no, then second sentence will apply and supersede the provision to the extent of incompatibility. Next slide, please. Now we come to first sentence of Article 16.2. Please note that there is no reservation allowed in respect of first sentence of Article 16.2 and about the both sentences of third paragraph of Article 16, or rather Article 25. So do all parties notify absence of existing provision under Article 16ci? If yes, first sentence of Article 6.2 applies. If no, first sentence does not apply. It is relatively straightforward. Second sentence of Article 16.2, which is about the implementation without any time restriction of the MAP resolution. Does either party make reservation under Article 16.5c? Now there are two limbs of Article 16.5c if you would look up. The first one is that a country feels that it will be able to implement this measure of implementing the MAP resolution without any time limit. Then there is a second limb where the permission to have a reservation is based on that country agreeing to not make transfer pricing adjustment or a P profit attribution related adjustment beyond a and not or beyond a fixed time limit, and that it will not make the adjustment beyond this time limit. The idea there is that domestic time limitations come into play where the adjustments are made very late, and if the country makes a promise that it will not make the adjustment beyond a certain fixed time limit, which is normally not very long, it would be 5 years. If I could not just look up before this session the concerned treaty I was planning to, but then they are within their rights to have a reservation. So if the party makes reservation under Article 16(5)(c), yes, second sentence does not apply. And if no, then do all parties notify absence of existing provision? This is also important, because if it is absent, then it can, yes, as you see at the end on the right side, then second sentence can apply directly. But if they don't notify absence, then it would not apply, because then there could be a conflict. Next slide, please. First sentence of 16.3 and second sentence of 16.3, I'll take them up together. Both are on similar pattern. No reservation is allowed against either of them. So if do all parties notify absence of existing provision, then if yes, first sentence of Article 16.3 applies, or second sentence, as the case may be. And if no, first sentence or second sentence of Article 16.3 does not apply. Next slide, please. Now, as I was telling you, India has submitted its position on MLI, detailed position. You can look at that position if you search for the MLI positions of countries, and on OECD website for all the signatories and ratifiers of MLI, you will see the position. The chart will be somewhat like this: that the name of the country, then the date of signing, then date of instrument submission of the instrument of ratification or approval. So those are live links, those dates. If you click on those dates, you will be able to see the provisional position, which is on the date of signing. As you would have learned by now, that under MLI there were possibility of submitting a provisional position along with the on the date of signing or before signing, and later one could submit a final position at the time of submitting the instrument of ratification. So India had signed it on the first day when all 77 countries had signed, and this is the final reservation submitted on 25th June 2019. And there is only one reservation in respect of India for Article 16, which is about that presentation to either competent authority of the map request, and India has committed to follow the optional provision to meet the minimum standard, which is that country will implement a bilateral notification or consultation process with the competent authority of the other contracting jurisdiction for cases in which the competent authority does not consider the taxpayer's objection to be justified. So that's how the minimum standard is met, and we had been doing that bilateral notification. Next slide, please. Now, this is an example of notification, because I would also recommend to you to, because MLI's language is very complex. If you start reading MLI and try to correlate it to the real situation, you may get a little confused. I would recommend to you to see the position of India on the website and start from the reservations and notifications, pick up a specific case, and if you work backwards, it will automatically dawn upon you how the article or the provisions are designed to operate. Now, India notification on Article 16 of MLI. Here, this is the notification made by India in under 16(6)(bi), which was, I think, about the time limit, and 16(6)(bi). Let me just once again confirm. Yeah. So where the time limit is shorter than 3 years, these are the countries which were listed by India. Next slide, please. Now, this is a notification under 1 minute. Let me see. BI2. So where the time limit is more than 3 years, so very large number of countries are there. I have captured only a part of it. All this I have done to demonstrate to you the real application of MLI besides talking about its principles and content. Next slide, please. Now I have a very good example for you to show you the importance of the speed matching exercise which I carried out with all the countries for India and to resolve the mismatches between the provisional notifications by the two countries. So here is an example of India Greece treaty. What is the fact is that as I would show to you that India made a notification. You can see it is available in the public domain. You can see it on the first date, which is 7th June 2017 for India, as to what was the notification by India on 7th June 2017, signature date. You can also see the later notification or final notification by India, final notifications by India on the date of submission of the instrument of ratification. Similarly, you can do it for Greece, and we are going to see it in next 3 slides, and this one included 4 slides. So here what I am trying to demonstrate to you, please see that for the notification under Article 16, Article 16 6CI and Article 16 6C 2I, Greece was notified by India under both. So Article 16CI is about the time limit, and so India did notify Greece under both. Now please proceed to the next slide. This is the initial notification by Greece on the date of signature. As you can see, India is missing under both the tables at the top. On the first one, only United Kingdom you will see, and under the second, there are 6 countries, but India, 6 or more countries, but India is missing. So we can, next slide, please. Yeah. So now this is the India final notification. For the purpose of this exercise, which I am doing, just concentrate on Greece. Greece figures in both. Again, because we believe that India-Greece treaty fulfills this notification requirement, and it was notified. Next slide, please. Now look at the Greece final notification. As you would see, India is now figuring under both the tables here, and this was due to the speed matching. As you can see in the first one, instead of United Kingdom, you can see Germany, USA, Sweden, and India besides United Kingdom. In the second one, already there were some, but now you can also see India at number 19. So therefore, this was as a result of speed meeting between the two countries to resolve the mismatch. And finally, now there is convergence on application of this provision by matching the notifications between the two sides. Next slide, please. Now, I also thought I will tell you about synthesized text. So to my recollection, there are about, so what is synthesized text? As we talked about, the MLI is not an amending protocol. It is basically, it is different, and it operates alongside the bilateral treaty, and therefore one has to sit down and apply the provisions together to make out what exactly does it entail. So since the OECD had a discussion on inclusive framework, no, at that time only OECD had a discussion on this, and there was a thought about issuing a synthesized text even unilaterally or bilaterally by two countries agreeing together, or one country issuing it on its own, which would then capture the application of MLI on that treaty and issue it in public domain, and with a disclaimer that this is not the final legal version. The countries, I mean, it cannot be said in the court that this will be binding on the country. But this is the purpose of the synthesized text, and I believe it has been of great deal of help. So I also participated in finalization of synthesized text with quite a few countries. Here I am giving you an example of the synthesized text through India-Canada DTAA. So what I put on the screen is Article 25 in the treaty, and I'll request you to focus on the second sentence of paragraph 1. So the second sentence says the case must be presented within 2 years from the first notification of the action which gives rise to action taxation not in accordance with the agreement. As you would recall, the minimum standard is minimum 3 years and not 2 years. So this has to be changed. And I'll also request you to see the other provisions here in the MAP article of India-Canada DTAA. I am sure you would have noticed the missing sentence in paragraph 2 about implementation of MAP agreement notwithstanding any time limit. So these are the two things that are missing. Other than that, of course, the first sentence of first paragraph is different from the MLI or the OECD Model Convention 2017. But as we know, India has made a reservation, so that's not important. Here, these two aspects are important, and I'll show to you how this has got changed through the MLI and how the synthesized text has dealt with it. Next slide, please. Now, this is firstly, let me deal with the second sentence of the second paragraph. And this would bring to you a real situation where a country is taking the position which we talked about putting a time limit on making adjustment relating to PE profit attribution or the transfer pricing adjustment. So Canada is one such country which in its MLI position, this is the instrument of ratification position, that's final position submitted on 29th August 2019. And here you can see clearly A and B are covering both of those aspects, and Canada is therefore free from implementing the minimum standard by inserting second sentence of paragraph 2 of Article 25. It has committed to do this rather than insert the second sentence of paragraph 2 of Article 25. So now first, out of the two problems we saw in the previous slide, one is taken care of and one only remains about the shorter time limit of 2 years for presenting a MAP request. How that is dealt with in the synthesized text, which is based on the notifications, is in the following slide. Next slide, please. So here you can see the second sentence of paragraph 1 of this agreement is replaced by second sentence of paragraph 1 of Article 16. So I'll not spend much time on this. I just wanted to show to you what kind of material or guidance you will see in the synthesized text. And this one is an illustration of that. I would request you to see as many synthesized text as possible along with the original treaty, and then it would become more and more clear. The beauty of the MLI is the more you read it, the more you will get familiar with it, and the more you will start liking it rather than hating it. Next slide, please. So this is the continuation of the same thing, and rest is intact or not disturbed through MLI in the synthesized text. Only this sentence is replaced by the sentence in the box there. The case must be presented within 3 years from the first notification of the action resulting in taxation not in accordance with the provisions of the agreement. So that takes care of this. Next slide, please. So I'm through with Article 16, which is relating to Article 25. Now I move on to Article 17, which is about corresponding adjustments. As you would all know, it's a very important article in respect of transfer pricing adjustments, what is called a correlative relief by the country other than the one where a transfer pricing adjustment is made. Now, element 1.1 of Action 14 minimum standard also provides, you would remember when I showed you element 1.1, I had told you that this is half of the element 1.1. The other half is here. Minimum standard also provides that countries should provide access to map in transfer pricing cases and should implement the resulting mutual agreements by making appropriate adjustments to the tax assessed. So this is what the Article 9.2 of the OECD Model Convention is what is being envisaged here. And let me also tell you here that you would remember that India had a position sometime back prior to 2017, if I recall correctly, that we would not do MAP or bilateral APAs, transfer pricing MAP or bilateral APAs with countries where treaty does not have Article 9.2. So this element is basically also saying that with or without Article 9.2, you must do transfer pricing adjustments. And the government had issued a press release or a notification, I think it was a press release, where we said that the India has now ready to do the transfer pricing map and bilateral APA, even in case of countries like they did not name, but I'll give example of Germany and France, where there is no Article 9.2. So what I'm trying to say is that insertion of Article 9.2 is good, but not necessary. And it would facilitate, may bring clarity, but even without it, transfer pricing correlative relief can be done, and transfer pricing adjustments related map is possible. It's not a minimum standard. Article 17 is not a minimum standard. Only the transfer pricing, please don't confuse it by my listing element 1.1 or second part here. Article 17 is not implementing the minimum standard. Element 1.1 is requiring implementation of the minimum standard, and Article 9.2 is just one way of further facilitating transfer pricing map. Second bullet point, Action 14 report noted that it would be more efficient if jurisdictions also had the possibility to provide for corresponding adjustment unilaterally in cases in which they find the objection of the taxpayer to be justified. This is the Action 14 report. Best practice one states that jurisdiction should also include, so it is a best practice, as you can see here. Article 17 of MLI is basically a step to implement a best practice. Next slide, please. So how much time we have spent so far? I think we don't have that much time. We have time up to 11, Prerna, isn't it?
Yes, sir.
Okay, so I'll skip. I'll go a little faster on this because I have a lot of interesting material for you ahead. So Article 9.2 is basically about where I think I think I will come back to it if I have time. First, let us go to other parts. Let us go ahead. Basically, Article 9.2 is correlative relief related formulation, as you can see on the screen. Article 17 of the MLI is just reproducing Article 9.2 with suitable adaptations, and then there is a reservation. Next slide, please. Let me see if I can cover it very fast. So substantive provision, paragraph 1, identical to Article 9.2 of OECD Model Tax Convention. Then paragraph 2 is a compatibility clause in which identifies as to which are the provisions in respect of which paragraph 1 will identify. In generic terms, it is described. That is always the way compatibility clauses are drafted. Next slide, please. So this will take time and I will not go through this, but you can read the Article 17 and it would become clear to you when and where, based on the combined operation of reservations and notifications, Article 17.1 language will get inserted into the tax treaties. Next slide, please. Now, this also we'll skip. This is just for information. There are few differences between OECD and UN model. OECD has mandatory arbitration. UN alternative arbitration may be initiated if the competent authorities are unable to reach agreement on a case within 3 years rather than 2 years. And the mechanics of two are different. But since India has not adopted arbitration, let's not go into detail of that. Next slide, please. Competent authority is usually defined to be the finance minister or his authorized representative, and then it is delegated to the lower authorities. And in our case, these are the two joint secretaries, 1 and 2 in the CBDT in Foreign Tax Division, having territorial jurisdiction over cases, one dealing with Europe and Americas, and two dealing with the rest of the world. Next slide, please. So this is just steps involved in a map process. Request is made, map is then to be accepted by both states, then taxpayer is to furnish the information, position papers are exchanged, face-to-face meetings takes place, then after that closing of the map is done and implementation of the solution is done. Next slide, please. This is just something to show you the kind of map setting. Next slide, please. The next slide, please. Yeah. So now we talk about some other important minimum standards of BEPS Section 14 and how India has complied with it. So first minimum standard element 2.1 is that countries should publish rules, guidelines, and procedures to access and use the map and take appropriate measures to make such information available to taxpayers. Countries should ensure that their map guidance is clear and easily accessible to public. So what has India done to comply with this? Rule 44G of income tax rules is there. Map guidance 2020, which is in fact the main guidance, supplemented by short guidance of map 22. Then minimum standard element 2.2, countries should publish their country map profiles on a shared public platform in FTA map forum template. The website where you can see this is below. So all country map profiles are there. India map profile is there. You will find lot of information there on the map position of India as to what it will do in case of anti-abuse matter being involved in the audit, and several other things, what it will do when settlement commission cases there. All those things are listed there. Next slide, please. Then minimum standard element 1.5. Countries should provide timely and complete reporting of map statistics. There is a FTA map forum is a body in inclusive framework now, earlier OECD, which is basically collating the map statistics submitted by inclusive framework members, and countries are obligated to submit the complete reporting of the statistics as well as in a timely manner. Map minimum standard 1.6, countries should commit to have their compliance with minimum standard reviewed by their peers. So this is very important, and it is having lot of effect all over the world over map provisions being implemented, that a peer review is done by the inclusive framework FTA map forum, depending on after calling for information from the countries, and then they have a questioning and further information they seek, and finally a report is released. So you can see India report for two of its reviews in the public domain and see what kind of observations have been made by peers on the map process of India. Next slide, please. Next slide, please. Rule 44G of IT rules, you can look it up. Because this is very important, and this drafting I was part of, and we changed the earlier rule completely. And this has, I think it has really helped. Now, application is to be made in form 34F, and then let me just pick up the important ones. Fourth bullet is important, that competent authority is to endeavor to arrive at mutually agreement solution within an average time period of 24 months. This is also there in the minimum standard, and therefore in the rules also it has been inserted. Fifth is very important, map resolution to not result in decrease of income or increase of loss of tax paid in India as declared in return of income. This is basically Article 92(3). We will see further on this in the map guidance of India. Next slide, please. Next slide, please. Yeah. Then this is just the process. You can look it up. What process is there for basically a map to be, which is done through the treaty, to be implemented under the domestic rules. Next slide, please. Next slide, please. Now, salient features of MAP Guidance 2020. as I said, the main MAP guidance is of 2020, and the MAP guidance 2022 is just a supplementary guidance, adding very few things. So here also I'll speak about the only the ones which are important and need to be highlighted. In this slide, I see the things which are not so significant. You can look up the guidance by downloading the circular of the CBDT of August 2020 and read it. This is very important all everyone who wants to be involved in MAP in some capacity. Next slide, please. India can also accept multilateral map request, and that same shall be executed in the form of parallel or series bilateral map cases. Guidance provided on kind of situations cases where India will provide map access has been provided in the basically I'm saying that if you look up the map guidance, they have listed the kind of situations or cases where India will provide map access. Map access is also to be provided to non-resident entity in which case the deductor has been subjected to proceedings under section 201. However, the map discussion will in the non-resident case will be taken up only after passing of assessment order in its own case. Next slide, please. Now, circumstances where India would provide map access. Map access is a holy cow or very important because the OECD minimum standard wants widest possible map access. So India is the map guidance has after discussion listed situations where map access will have to be provided, but since India is not in a position or not in favor of granting further, it does not want to proceed further, therefore these are listed. So unilateral advanced pricing agreements, then if there is a unilateral advanced pricing agreement case, then map applications of years in respect of those years will be kept pending and taken up only after UAPA fails. Safe harbor cases and CAs, this one is important, and addition through this guidance that CAs, that is competent authorities of India, will not deviate from orders of ITAT where the dispute is decided on merits. So this is a very significant thing that was done through this August 2020 guidance. Next one, please. Denial of access to map, which are the situations in which access to map will be denied. So now let us understand this very clearly. Delay beyond 3 years, if there is a delay beyond 3 years time limit, whatever time limit in the map related article 25 of a particular treaty, after the minimum standard implementation, it will have to be minimum 3 years. It can be more also, but anything which is delayed beyond this will not be permitted to be entertained under map. It is not a case of like condonation of delay by the courts. MAP has this as a very strict requirement, and sometimes there is confusion about possibility of this getting condoned, and this will not be condoned is what I wanted to convey to everyone here. Incomplete map applications without documents information will not be entertained, although the CA or competent authority will provide opportunity to rectify the defects and provide the information or documents which are missing. Where order is passed by Income Tax Settlement Commission, their map will not be done. Here, access will also not be allowed. Where AR has pronounced advance ruling in case of Indian taxpayer or the non-resident applicant, then also map access will not be provided. Next slide, please. Downward adjustment. So, as I said before, when we were discussing the rule, that map resolution in TP cases cannot result in income going below the returned income. Section 92(3) is basically referred to, is the basis for this kind of a position. However, where a map case involves adjustments, transfer pricing adjustments in the other country, then Indian CA may go below the returned income to implement the map in full measure, is the position taken by the Indian guidance of 2020. Recurring issues, often this question is raised. If there are recurring issues, how would one deal with them, whether they would be dealt on the same principles or not? So the guidance clarifies that they would be dealt with on same principles. They can be, maybe. So I mean, why this may be? Because sometimes the devil is in the detail. When you go to the recurring, so-called recurring issues, you find that they are not as, they cannot be strictly speaking called recurring, and there are deviations. So therefore this kind of caution language is there. This is another question often asked. Interest and penalty consequent to the quantum addition cannot be resolved under MAP. Often people ask what happens to the interest and penalty. Now, MAP does not deal with this aspect, and it's not within the powers of the competent authority to waive the interest or waive the penalty, which is the consequent action to the MAP issue under MAP. Secondary adjustments, the MAP guidance has also referred to the section 92 CE, the secondary adjustment, where OECD commentary also in Article 9 has a section on this which one can refer to understand what secondary adjustments mean. And basically, it's about once a transfer pricing adjustment is made, the cash flow of the amount equivalent to the transfer pricing adjustment, the secondary adjustment requires it to be brought back to India, and options are there to pay interest or to pay 18% tax at one go to close the matter relating to secondary adjustment without bringing in the money. Next slide, please. Now, bilateral AP application already made MAP application on the same issue for same years will not be admitted by Indian CA in consultation with the other CA. Suspension of collection of taxes. This is important. There are memorandum of understandings with certain countries which are listed here: US, UK, Sweden, and Denmark, and as per which the collection will be suspended during pendency of MAP and on furnishing of a bank guarantee. So I saw so many cases where repeated bank guarantees are furnished, and the MAP is, because the MAP is still pending, and collection is not enforced in those cases. One case interesting is of Korea, where in 2015 this was signed, and now it has not got activated. It's reported in the press release. That's why I'm referring to it. But often people want to know whether there is a MOU with Korea on suspension of collection. So it's not there. So that's what I wanted to inform you. Next slide, please. Now, there is a supplementary MAP guidance of 2022 where VSV cases Indian CA will provide MAP access but will not deviate from VSV result. If in a case ITAT has passed any order, taxpayer, now this is why I'll explain you the background. Sometimes what happens, the competent authority does not come to know about passing of a order by ITAT, whereas under the MAP guidance, Indian CA is precluded from resolving a case under MAP where ITAT order has been passed. So the onus has been put on the taxpayer to immediately notify the competent authority that ITAT has passed the order. And why this happens is because of the internal mechanics of delivery of papers from here and there, that the CM and as competent authority is not a part of the normal audit and appellate framework or administrative framework of the IT department, and it may happen that he does not come to know about the passing of an ITAT order in a particular case. Now, 2022 guidance has put a lot of responsibility. There is a separate section on taxpayers' responsibility to make true disclosure and provide up-to-date information. It is said there that instances have come to notice where the information provided by the taxpayer was not found to be accurate, or therefore they have put this. Next slide, please. So we have come to the last slide, and basically I just wanted to tell you about in general about the MAP on these certain points, which is what are the major MAP partners. Article 25, as you would see, is in all of the 90 plus treaties of India, but the map relationship is not activated with all. And one reason is that we don't have map cases with all. The major countries with which we have map are United States of America, United Kingdom, number of European countries like Switzerland, Finland, Germany, France, and then Ireland, and in other side with China, Japan, Korea, Australia, Singapore. So with these countries, we have map, and there is an active relationship of the competent authorities by regularly endeavoring to resolve the cases. And after 2017 change, or with FTA map forum coming in being, the endeavor has in effect become an effort, or rather a strict effort, to resolve within average timeline of 24 months, which is a very welcoming move. Process variations are there in map between the various competent authorities and countries, but those would not really matter for the taxpayers, because taxpayer is not an active participant in the map, and how the competent authorities deal with it is not really important. Meetings, venue, frequency, duration, language, teleconference, etc. Venue is often one country or other, and it could be through teleconference, and after COVID through these meeting apps like Teams or Zoom also. Duration is generally 2 to 5 days, as I have seen, for a particular map meeting in person, if it is in one place and the other team is traveling to that place. Frequency would depend on the number of the inventory of map, and with few countries the frequency is very high, like US, UK, and Japan, and there may be 4 meetings also in a year to liquidate the pendency. And I can tell you that with Japan, we could liquidate, when I was the competent authority, almost all the pendency, and especially in transfer pricing. And India won the OECD MAP award for highest resolution in transfer pricing cases for the year 2019. And if I recall correctly, it was 64%, which is very high by international standards. And language is also important, and sometimes like a country like Japan has its own language being used, and then translation would be an important part, and interpreters or translators would be present during the meeting, who would be simultaneously translating after each averment by one team. And I found it to be very interesting and beneficial, because during that time, when suppose you have spoken in English and it is being translated into the language of the other side, then during that time you can discuss with your team as to what you want to do next. Otherwise, it may be an uninterrupted meeting and you don't get any time to discuss amongst yourself without taking a break. Team composition, some Indian team composition is like a competent authority under whom is a middle level officer called a director, and there are then case officers or under secretaries, maybe numbering 3, 4, 5. And other sites I have seen different composition also, like one man show. In case of some countries, the competent authorities would be 3. Basically, they were all delegated competent authorities, but each one will have its own case, and 3 of them will come and discuss their own cases. Sectors and issues. Now MAP has expanded to various kind of sectors, like in transfer pricing, all kind of issues like intra-group services, royalty, benchmarking, then of course comparability issues, TNMM related method of most appropriate method related issues, then corporate guarantee cases, manufacturing cases we saw, and allowing for what we used to call it, capacity utilization issues in case of manufacturing companies. So all that has all been proliferating over the years, and more issues are now being addressed under MAP. Competent authority relationship, this is a very important part of the mutual agreement procedure to work, because ultimately it is the humans who make a difference, and it's not a mechanical process. if the I have seen how much difference can it make. And sometimes because it's not obligatory to resolve, there may be competent authorities who would not want to resolve anything, be play safe, because after all it's a kind of a responsibility also you are taking upon yourself. Pardon me by saying this, but that's how the human psychology works. In fact, when I joined as competent authority, I was told by one of the highest officer that with particular country, I mean, why the indication was that why is it necessary? I mean, just go along with it. Our obligation is to endeavor to resolve and not really beyond that. And the sometimes the feeling is that of course the map would result in reduction of the adjustments made in your country, but after all that's a finality. I remember with great deal of fondness some cases where we could sustain a very high amount, of course in a judicious manner, and I'm sure that it would not have seen the light of the day in litigation for years. So competent authority relationship is about building a rapport with the other competent authority. It's done through a conversation or your actions which instill faith and trust into the other side, and they feel that you are one who can be trusted upon. Then only they will be forthright in agreeing to something. So I took some time to explain this, but I have always found it to be a very important building block of map resolutions and map framework. So next slide, please. Prerna, next slide. Okay, so we have come to the end of the presentation just in time, I think. So I'll stop here.
Yeah, thank you so much, sir. If there are any questions, the participants can just post it in the Q&A box. I can't see any question.
Sorry about this. I had put off my phone, but why this is... Yeah.
No, sir, I don't think there are any questions. So I think we can just conclude the session. So thank you so much, sir, for the interesting session. I think we really gained a lot. At least I gained a lot from this session in terms of your experiences with the map, how India is progressing towards the map. And I think with that, we can just conclude the session. So on behalf of IFA, I would just like to extend a hearty vote of thanks to you for sparing your time for sharing incredible knowledge to us and your experiences with respect to map. Thank you so much, sir.
Thank you very much, everyone. Thank you.
The participants can join a separate link for the next Brain Trust session. You can just leave this particular link and join through a separate link.